4, 2012. This is Justice Done Dirt Cheap. We are going down to file some paperwork. Going to be filing a notice of motion for leave to appeal the decision I received on April 27, 2012, where I filed a motion where I wanted the court to grant extension of time for service and filing my notice of motion for leave. My notice of motion or extension of time for service and filing of a post-hearing brief. See, what happened is, at a previous hearing in August 2011, I had requested the court to permission to file a post-hearing brief because I had asked the Justice Clendenning to make an order ordering the Fredericton Police Force to do an investigation into the volume of calls that the Fredericton Police Force received regarding my residence over the past 7 years. Those calls are numbering in the hundreds, and it's over nothing. Someone keeps calling the Fredericton Police Force, providing fraudulent information. The legal term is fraudulent misrepresentation. Because of that, the Fredericton Police Force keep arriving at my residence, looking all wild-eyed, looking for something amazing going on, when there's nothing. The few times over the past few years that I was unable to get inside quick enough, I was arrested, assaulted, dragged down to the police station, then released without charge because there was nothing to charge me with, because nothing was actually happening that would have warranted the Fredericton Police Force to arrive. So because someone is providing fraudulent misrepresentation to the Fredericton Police Force, I was asking the court to make an order, because under the Right to Information and Protection of Privacy Act, the court can make any other order regarding disclosure of information that the court thinks is appropriate. So I was arguing the court should do that and order the Fredericton Police Force to conduct an investigation to find out exactly how many calls have been made over the past 7 years that have resulted in the Fredericton Police Force arriving at my residence. And I'd like to know specifically is, in the totality of calls, say we'll pick a number like 200. Imagine 200 calls over 7 years. If 175 of those calls are from the same number, then there's something wrong. Now, if those calls were from a whole bunch of different numbers, that would be revealing as well. I believe about 99% of those calls are from the same number. Someone who's using the Fredericton Police Force to vicariously harm me. I want it to stop, and the way to do that is by filing a referral, which I did, and asking the court to grant relief, which I did. The court wasn't convinced at the time that they could grant the relief I was seeking, so I asked to file a post-hearing brief, which could convince the court to do so. I had a month to file it. It was for my benefit. I ended up being a week late, which is unfortunate, but it happens. And when I filed and served it, the solicitor representing the other side, Debora Lamont, who represents the New Brunswick Police Commission, objected to it being filed 7 days late. Now, this didn't affect her client whatsoever, because the order gave her the option, if she wanted to file a response within 30 days. But what's amazing is that the order didn't even affect the New Brunswick Police Commission. It was to order the Fredericton Police Force to actually grant the disclosure and conduct the investigation. So there was no benefit whatsoever to the New Brunswick Police Commission in objecting to this order. All that occurred was A lawyer got paid to show up at a hearing. Since the New Brunswick Police Commission is not a private body, the public body, you, the taxpayer, paid for Debora Lamont to show up to argue that ridiculous motion, which didn't have to be filed or argued. I spent a lot of time and energy preparing for it, and in the end, the judge refused my application, despite the solicitor for the New Brunswick Police Commission, Debora Lamont, not providing any affidavit material, no written briefs or submissions, nothing contradicting what I was saying. The sole position they had was she was claiming that this is claiming quite simply that the order was the thing was filed, the document was filed late. And amazingly, though there was no prejudice to her client, the judge, Justice Clendenning, accepted that and ordered accordingly, which is wrong. The rules of court, the spirit of the law, all state that the rules of court are supposed to be used to provide a remedy and not to be used to bar people from the substantive law. So, that decision was wrong. Today I'm filing leave to appeal because it's an interlocutory, it's an interim order, which means it's in the meantime. It's not a final decision. It's something that's going along in the process. The merits of the matter have yet to be decided. So when that happens, you have to file leave to appeal. So I've done that. Now, it's amazing that the only person that benefits from the objection was the solicitor representing the police commission. She got paid to be there, and the only thing she did was say, object, because the order said a month, and I filed a little bit late. She didn't claim her client was prejudiced in any way. No reason whatsoever other than just calling a foul without good reason. It's wrong that lawyers act like that. So we're filing the notice of motion for leave to appeal today, and going to get this decision overturned hopefully. Thanks for watching. This is Justice Done Dirt Cheap, May 4, 2012.